Now we're going to look at common ethical dilemmas in community services sector here in Australia. The common ethical dilemmas that social workers, community service workers have collectively experienced in Australia are around issues around clients' autonomy, that is, clients' right to self-determination, significant issues around confidentiality, privacy, informed consent, which we'll look at next, differences associated with clients and also practitioners' morals and values, boundary crossing associated with dual relationship, and administrative dilemmas. These were reported in 2017 ACWA survey. Now, informed consent in Australia involves the right of the client to be fully appraised of the professional process by the practitioner to a degree where they can make autonomous decision about their engagement with a particular organization or with a particular service. It's also applied in healthcare. It's also applied in counseling and psychotherapy, psychology as well. You know, in Australia with our state health, we have clear, explicit ethical codes as well to deal with informed consent process as well. In community services, the worker and the client, you know, basically they put their cards on the table to come to a collaborative agreement. It kind of involves drawing an agreement between, you know, the parties. When you don't have informed consent, boundaries become blurred as well. Roles can be confused, and there could be also possibility of you know, unsatisfactory outcome. Generally, in Australia, informed consent involves client understanding. It's where the worker clearly discusses confidentiality, privacy, professional options, documentation process, procedures, and perhaps even in the intake and emergency contact information. The voluntary nature of these services is also discussed. The client has a right to walk away from the service at any time. And the scope of work can also be discussed in the informed consent, and a client also authorizes as well, or the worker also gets client's authorization for consent to work on the client's behalf. So the capacity to consent is also extremely important. The Australian laws have placed emphasis on understanding, comprehension of the information than on the age. But generally in Australia, depending on the state you are in, anyone above the age of 14 can provide consent for healthcare services. You know, the Australian courts have also emphasized on adequate information as well that needs to be provided in the informed consent process. So here the worker has the responsibility to clearly discuss every aspect of their engagement, including confidentiality, privacy, documentation process, what the options are. And as I said before, the voluntariness of the engagement is also discussed. So I'll direct you towards the tutorial activity now. You know, go through the tutorial activities on your Moodle, and I advise you to research on ASW Aqua guidelines for ethical practice and list all the information a client needs to make a reasonable decision on whether to access community service work or community services. Discuss this with your lecturer during the tutorial. I've listed a few points that a good community service work informed consent contains. So the 7 points here, and this is just based on general community service work. And as I said before, healthcare professionals and other social work professionals develop clear guidelines on informed consent, and it needs to be adapted to the work they do as well. So generally in community services, we talk about the nature of professional work that we provide, whether it's homeless shelter, homeless case management, crisis management, counseling, therapy, psychological services, whether it's domestic violence services, anything that the organization is providing needs to be described in the informed consent. The recording of the information that's discussed in the client professional meetings, information about the client obtained from the third party, and any other information pertaining to the client needs to be discussed, and the client needs to be told who has access to that information. The client can also talk about, the worker can also talk about the professional risk and benefits associated with engaging with the community service organization. Then the worker can also talk about confidentiality and limits. Basically, everything the client says will be confidential except in 4 scenarios, which we'll look at more in detail next. But the 4 scenarios are when there's a danger to self or to others, when it's mandatory under child protection law in all the states and territories in Australia, when it's subpoenaed, that is an order by the court, or when a client has an impaired capacity and a public guardian appointed. The client also has a right to obtain a second opinion as well. You could also talk about the voluntary nature of the service, and the access to information about the client within the organization and who has as well needs to be discussed, and the client's right as well to see their case notes and making a formal complaint as well. So we'll move on to privacy and confidentiality now. So in your class activity, I would advise you to reflect on both the difference between privacy and confidentiality. So what are the difference between privacy and confidentiality? And you could discuss that with your tutor during the tutorial as well. The confidentiality refers to a privileged communication between a professional and a client, and that information needs to be kept confidential. It's one of the most common breaches of ethics in community services sector. It's also most common breaches in social services sector and in health profession as well. It can happen on a number of levels, and I'll discuss that. Well, privacy is also related to confidentiality, but goes deeper. It's a more profound moral and ethical consideration. Now, privacy refers to the right of an individual to keep his or her privileged information private, to prevent unwanted intrusion as well into that information. Now, it's a moral duty and a legal requirement. One of the common questions I've heard in community services and social work by the client is, will everything I say be kept confidential? We say, yes, it's a moral duty and a legal requirement. All clients in Australia have a right to confidentiality and privacy. And we keep that within the bounds of professional relationship or within the organizations. We don't disclose it outside the professional relationship. So it's seen as a client's property. It's it's their information and therefore needs to be protected. So it's protected by the law. It's an establishment of privilege by statute, and in Australia, it's related to two laws: Privacy and Personal Information Protection Act, the Federal Privacy Act as well of 1998, and you could also access the relevant state or territory health records and information privacy act as well. Aqua Code of Ethics talk about privacy, and your ASW Code of Ethics as well talk about privacy and confidentiality. So we have an ethical and a moral duty to maintain confidentiality, and again, as part of your training and during your field work, you'll become aware of these laws and guidelines. But remember, one of the foundations of our work in community services is establishing trust between ourselves and the client, and this trust also implies privacy and confidentiality. Now, as part of your reflective activity, what I would advise you is to reflect on the organization where you might be working currently, and reflect on their privacy and policy procedure. You could also reflect on your own practice in relation to privacy and confidentiality, and what you might do in regards to continuing to maintain privacy and confidentiality. Now, agency under Australian laws have certain responsibility as well. They have responsibility to collect only what it needs. So if a client has come for a homeless service, or clients come in for crisis accommodation, they just need to know the basic. For homeless service, they may need to know a little bit more, but it's only pertaining to the service that you're providing. You don't intrude into a client's life and collect unwanted information. Agencies have policies around disclosure of personal information as well for the purpose it's collected. These can be to do with health, safety, legal requirement, or for funding requirements. In those cases, the clients are de-identified. The agency also has a responsibility to ensure that the information it collects is accurate, complete, and up to date. So consent forms, addresses are all updated. Agency also has a responsibility to keep that secure. So by law, we need to keep the case notes or any client information securely locked, or if it's kept in digital format, it needs to be kept in a password protected computer, and it's encrypted. And also agency need to be very clear about what it does with people's information, whether they're going to put that in an annual magazine, or whether they disclose it to other agencies. Agency need to let the client know what it does with other people's information. And the agency also has a moral duty and a legal requirement to let the client see the information it holds about them, and also the client have a recourse as well to correct it if it's necessary. Agency also has a responsibility to minimize using those records for um, you know, by multiplying or for multiplicity, um, and um, and in certain cases give people as well an option not to identify themselves. Um, and Agency also has the responsibility to securely transmit that information um, when it's being transmitted outside the organization. This again is based on client's consent. Um, and agency doesn't collect any other sensitive information about the people, such as, it could be around race, ethnicity, religion, political views, sexual preference, without clarifying the relevant laws. So what might be confidential data in community services? Pretty much everything that you have about a client is considered confidential. So they are personal and identifying information provided by clients. It could also be about their employment, family, social life, any information that the client provides during engagement. And this could be about how they became homeless or what the circumstances are, how they lost a job. All the information provided during engagement needs to be kept confidential. The records of the client that comes from your agency and other agencies are confidential as well. And all the correspondence between you and the client, this includes email, text messages, phone calls, written communication, needs to be kept confidential. So personal information, Australian courts have placed emphasis on what is reasonably identifiable. And so reasonably identifiable to that particular individual. And personal information in Australia can be verbal, written, photographic, videographed, could be recorded or unrecorded. It could be true or false. But basically anything that's identifiable. So that's a person's name, contact details, date of birth, gender, sexuality, race are classified as personal information. Now we're going to look at sensitive information. Now, sensitive information is slightly different. It's classified as a special category of personal information, and it has more strict privacy law applications as well for collection, storage, and use. Now, a sensitive information is an information that is related to a person's race, ethnic origin, or political opinion, perhaps even a membership to a political association, religious belief, philosophical beliefs. And generally, organizations don't need this. It could also include membership of a trade union, sexual preferences, criminal records, although there are exceptions to this as well, and health or genetic information. Sensitive informations are not collected by community service organizations. Some organizations may have a voluntary disclosure as well in their intake form around sensitive information, just for monitoring purposes only. So if an organization that wants to show that it's very open and welcoming, it may contain a voluntary disclosure around racial or ethnic origins or religious beliefs or sexuality preferences. But generally, we do not consider sensitive information. We don't ask for sensitive information. And sorry, sensitive information is not the basis as well for a client engagement. Um, so if I'm collecting personal information or sensitive information, then there's an obligation on me or my organization to take reasonable step as well. As I said, in the informed consent process, in the intake forms, you could talk about personal, sensitive, and health information and why it's collected. We need to notify the individual as well clearly why it's collected, otherwise it becomes illegal. And who we may share the information with as well. And we also have to comply as well how we hold that information and who we can disclose it to. And also if the information is going offshore, then we need to explain to the client why the information might go offshore. And we also give the client the right to to have access about the information. And by law, all organizations in Australia have to display their privacy policy publicly. As I said before, the parameters of confidentiality are best set during the informed consent process as well. But we also have a responsibility as well to ensure that the information we collect is kept safely and securely. So, depending on the organization circumstances, the organization needs to ensure that the client records are kept securely. If it's kept in electronically, it needs to ensure that there are restrictions as well on access to information. All are password protected, and there's various layers as well of protection and on access to information. You could also have personally, screen blockers as well to prevent visitors or unauthorized access to screen. Policies around keeping all the client documents in locked drawers as well. And at the time of you finish work, you ensure that you don't leave any case records or case notes lying around on your desk. So this restricts as well or prevents unauthorized access or disclosure of personal information pertaining to the client. And also organizations can limit the use of portable storage devices. Well, we all know, we all take laptops home, but the organizations need to ensure that the laptop cannot be accessed by any other member of family, or if you have USB keys, that it has encryption on it and it's password protected as well. Most organizations in Australia also have a record of audit trail as well, so that they access documents and ensure that they're kept where it should be. And also policies around electronic communication as well. Today in a digital world, you'll be involved in communicating with the client online. So, and organizations have guidelines as well. You don't disclose email addresses accidentally, email addresses of your colleagues. So if you're sending communication to multiple clients, you put their email addresses in blind copy, the BCC, than in the to send or send us address list. You also have a responsibility to ensure that volunteer details are kept confidential and who can have access to that information. And you also have regular training sessions as well associated with confidentiality. And at the end of the day, when the employees leave or volunteers leave, they need to provide all the client materials back to the organization. So there's a couple of case studies on the slides. You might want to use that to participate in the um, tutorials. You could also post it on the forum as well. There's case study one where, a scenario where a student posts a Facebook video, a video onto a Facebook page, which is a breach of confidentiality, and an issue associated with mandatory reporting, which we're going to look at in the section 3 of our video lecture. There's multitude of examples where confidentiality has been breached. It could be because of genuine mistake or accidental mistake, where a client file is left on the desk, or the worker leaves the client file in a cafe, or leaves a computer on in a cafe where others can see the case notes or whatever the worker is typing on the computer. Worker can also breach confidentiality primarily to satisfy the curiosity as well, to see what other clients might be doing. Worker can also breach confidentiality by because of insubordination or insider revenge, where worker wants to have revenge on the organization, and therefore breaches the confidentiality so that the organizations can't be harmed. This is illegal in Australia. Involve uncontrolled secondary usage, so where the client has actually not given the consent, but it has been inadvertently used for other purposes. For example, you may take pictures of the organization. The organization may have a cafe or a dining area where the clients come and eat, and the picture contains client identifiable information, including photographs, and that is published in the organization's website. And also unauthorized hacking or use of another password as well. So going to exceptions to confidentiality, as I said, there's this, everything the client says is confidential under Australian law, except when there is a danger to self or the others. This is under duty of care. We have to contact the emergency service organizations or applicable services as well in some cases to protect the client or to protect others as well. So when there's danger to children, it's mandatory in all the states and territory. And when it's subpoenaed, what is a subpoena? Subpoena is a court order that requests someone to testify or an organization or someone to produce documents. It's a court order. It's illegal to ignore in Australia. And if I fail to do so, then I may be charged with contempt of court. It's a serious offense. But we have policies around subpoena as well. I advise you to research on it, but I will give you some directions. When a subpoena comes, when it comes to you as an individual working for an organization, or when it comes to an organization, you need to notify your seniors immediately. The organization will also have a policy of notifying the client as well that there is a subpoena. It's up to the organization to decide to fight the subpoena or to comply with it. In most cases, organizations will comply. They have a standard 14-day time limit, and the copy of the documentation requested is given directly to the court of law. The client needs to be informed as well, but the client does not have a say in the process of subpoena unless they challenge the subpoena themselves through their lawyers. We're going to look at client notes and records. In community services, it's a professional practice for us to, or any competent worker, to take notes and to keep records. We can't rely on memory. It's very dangerous and it's negligent. If we don't keep the records, we also do clients a disservice as well. So we looked at it in the last section. The confidentiality ensures that all records are safe and secure. But so in relation to note taking, think of case notes as your diary of encounters with a client, and records as more of a functional business side of your relationship with the client. That includes name, date, if they've paid any fees or bills, or any other administrative task associated with that client. So we keep those for documentation. We keep that for legal reasons as well, including defense. We keep that for statistics. We keep that for for supervision purposes. We keep that for identifying progress. So pretty much everything that you interact with the client is kept in the case records. That includes consent forms, case notes, and any treatment plans as well. So with the case notes, there are certain principles that we need to follow. We need to be very accurate and objective. We can't bring in our subjective values and biases in the case notes. We use simple English. We also use direct style. We use simple language. We summarize in community service case notes what the client has said or what we discussed in this session. It's also a good practice to record immediately after the session. We can't rely on memories, or we can't build backlogs of information as well. We avoid uncommon information such as abbreviations and acronyms as well. And we only record relevant information. So the best practice of taking notes is at the end of the session, or you could also do it during the session as well. But you need to summarize what has happened in the session at the end of the session and upload it onto your case file or the client's case file or to the organization's server straight away. So, don't contain any third-party information that includes hearsay, gossip, rumors, your own frustration feelings, details that are not relevant to client position. And according to the state legislation as well, you need to consider what is incriminating information, what is not. And I would suggest that you speak with your supervisor regarding this. So case notes, again, just a reminder, consider best completed at the end of the session when your memory is still fresh.